permission from your client to waive his presence?
Good morning, Your Honor. Yes, we have.
All right, Mr. Rafferty.
Yes, Your Honor. Good morning.
Good morning. So we have three motions teed up for this morning, and why don't we dive right in, beginning with the motion to speak with the grand jurors, joined by Ms. Powell.
Judge, just as a preliminary.
Okay, here's the first problem, folks. You have Attorney Nathan Wade interrupting the court at the very beginning of this. All right, my friends, welcome to everyone. Get ready because it's time to free your mind. J.R. Dukes with you. We are in the middle of an investigation into Attorney Nathan Wade, who, of course, is the prosecutor / lover of DA Fani Willis of Fulton County, Georgia, of the RICO case fame. Now, we have been looking into Nathan Wade because obviously there has been a lot of speculation in the legacy media. Frankly, there's been speculation everywhere that this attorney, Nathan Wade, essentially has no experience whatsoever, especially with any type of felonious case, much less any type of RICO case. And that is what we're going to examine right now, because the reality is, my friends, Nathan Wade, as you're about to see, I mean, I want to be clear, this is absolute proof, visual proof that Nathan Wade does not have the chops, does not have the experience to be prosecuting, aka persecuting, depending on your point of view, Donald Trump or any defendant in a RICO action. This guy is obviously an amateur. I got his photo right over my shoulder here for you to look at. This is directly off his website. Please recall yesterday we had a video that I put out that basically went over his website. It is clear from his website this guy is an ambulance chaser, aka personal injury lawyer with minimal experience in other areas and no experience that we can find as far as felonious prosecution, especially a RICO case. I mean, RICO is about as bad as it gets, civil and criminal. It carries a minimum 20 years upon conviction, no discretion by the judge. And this is the type of guy they put in charge of a RICO action, especially against a former president of the United States. So that's the reason why it's important to look at the scandal that is going on between him and his lover, the DA Fani Willis, and all the people associated with them. So without further ado, we're going to get right into this video. This is a court hearing that was taking place in Fulton County, and we're going to talk extensively about the actions of attorney Nathan Wade. So I believe this was the second hearing in this RICO case inside the Fulton County Courthouse. The judge is present on one side, which should be your right-hand side. You'll see Nathan Wade, who is sitting right, if my mouse shows up, yeah, there it is. You have Nathan right in the middle of your screen, attorney Nathan Wade, and the individuals beside him are the additional attorneys that are working with the state to prosecute this case. On the other side of the room, on the other tables over there, is essentially two of the defense attorneys that have two defendants essentially represented for these particular hearings. Now, let's pay attention as we go through, and we're going to start right now.
Received express permission from your client to waive his presence?
Good morning, Your Honor. Yes, we have.
All right, Mr. Rafferty.
Yes, Your Honor.
Good morning. So we have three motions teed up for this morning, and why don't we dive right in, beginning with the motion to speak with the grand jurors, joined by Ms. Powell.
Judge, just as a preliminary.
Okay, here's the first problem, folks. You have attorney Nathan Wade interrupting the court at the very beginning of this motion hearing, okay? There's supposed to be three motions that they are basically having a hearing about. The first motion is a motion to speak with the grand jurors. The second is a motion to unseal the grand jury testimony. And the third motion is a motion to disclose the co-conspirators, what they call the unindicted co-conspirators in this particular matter. Listen to how kind the judge is, how he tries to go out of his way not to embarrass attorney Nathan Wade. He is trying to basically use what I can only best describe as kid gloves. And he's really, really trying to help out Mr. Nathan Wade, who clearly does not know what he's doing. So let's get right back into it and we'll talk about it.
Matter. The state intends to comply with all of its legal and ethical obligations to turn over the co-conspirator information with just the understanding that the reason why the names of the co-defendants are not already in the indictment, Judge, is that courts are frowned upon putting the individual's names if they're not charged within the charging document. We'll turn those over to the court with a request that the court hold them under a protective order, so to speak, to protect the identities of those individuals or to control, I guess, the public impact of the names that are on that list.
All right, so it sounds like you want to skip to number 3, the motion to disclose the co-conspirators.
Well, just to do away with,
right,
kind of streamline it.
All right, let's start with that one. It might be the easiest to get into. So let me make sure I'm understanding what I'm hearing. So you're wanting to, you are willing to go ahead and just give this list to defense counsel informally through the discovery process? I'd
like to present it to the court.
Okay.
The court can then distribute it to defense counsel as it sees fit, but it's the state's position that because the practice of naming the co-defendant, the unindicted co-defendants or co-conspirators in the indictment has been criticized. The state is elected to do it this way in order to protect those individuals and those names that are on this list.
Folks, this is just so crazy. This is hilarious. This guy is a clown. He clearly has no experience. This guy's a novice. This attorney has no experience in these type of cases. Look at the judge's face. He's like, okay, so you want to what? And he's trying to understand what's going on, and it only gets more confusing from here on out. This guy, he should not be in this position. This should have been a red flag from the inception that something smells, something's wrong. This guy has no business prosecuting a RICO case, much less any other type of major felonious case.
So
I'm tracking you completely there, and I agree. I think that's the standard practice. I'm curious why I would be the middleman. It seems like we could take the folder and just give it right to the defendants. I think that would be the regular thing to do.
Well, I mean, the court could impose a protective order that all of the parties to this case are subject to about disclosure of discovery to the media, if that is the concern of the government. But we have a trial on October 23rd. They have the list of co-conspirators. They're consenting to the motion. Why don't they just give us that information directly?
Sure, I think we're all about to reach the same place. So the bottom line is it seems like this is a fairly straightforward request. I think federally it would be a bill of particulars, and those are fairly routinely approved. So I can file an order if you want me to, but otherwise we'll say that the list of individuals 1 through 30 is going to be disclosed to not only, I would think, these 2 defendants, but the other 17 defendants through the discovery process and obviously right now. So in terms of a protective order, if the state's requesting one and the defense is not objecting, we can certainly do that as well. But otherwise, it seems like this is just a fairly routine part of the discovery.
We'll just look at the language of the protective order. Obviously, any protective order of not disseminating discovery or information to the media would have to work both ways. The state would also have to agree with that. But we have the list now, so
all right.
I guess it's the moot point.
I was just about to say that. So I'll go ahead and just enter a one-sentence order saying the motion is moot, and presumably this list is numbered so it can identify which count refers to which unindicted conspirator and that sort of thing, right?
Yes, sir.
All right.
And further, Judge, just to streamline today's arguments more so, the state does plan or intend to turn over the transcript of Mr. Cheeley's testimony, given that he's charged in count 41 in the indictment with perjury, and that testimony is an integral part of proving up our case.
Okay, so now we're moving on to number 2, the motion to unseal the special grand jury transcripts. Do we think we've addressed everything we need to cover with the unindicted co-conspirators?
Yes, Your Honor.
All right, anything else, Mr. Rafferty, you think we need to take up on that one?
No, Your Honor.
All right, thank you.
Folks, this is just the beginning of what I've been talking about with the inability of Attorney Nathan Wade to handle a RICO case or any type of felonious case. This is a complete joke. He has no business in front of this court, and now we know why he was acting the way he was acting. He has no experience prosecuting felonies, what we call felonious cases. This guy is a complete novice when it comes to this type of case, and in my humble opinion, it's only more evidence of the unbelievable scandal, the scheme, the corruption that is going on between him and Fani Willis, the DA there in Fulton County, their little love fest they got going on, and essentially their conspiracy to where they are taking taxpayer money via Fani Willis, paying it, and I use that word in quotes, paying it to Attorney Nathan Wade, and Fani Willis is obviously receiving benefit from the money that she's paying Nathan Wade. Folks, that's prima facie corruption. That's fraud. It's illegal. It's called honest service fraud, among other things. People have been put in prison by the Department of Justice for receiving airline tickets from vendors. This is so much more and so much more outrageous. It goes to what I've been talking about all along. If you're going to be throwing rocks at people, you better make sure you don't live in a glass house. These are yet another example of individuals who have come up against Donald Trump, and they end up having their own problems in their own backyard, and they either end up in jail or they end up in some kind of serious financial situation. This is something that I am definitely going to be following, and I'm going to keep an eye on it for you. Just absolutely ridiculous. Let me know what you think about it in the comments below, because I would definitely like to know what your sentiments are about this. My friends, be sure to share this video with somebody you think is indoctrinated, because the truth needs to be told. We need to shed sunlight on this entire matter and show it for what it is. It's a scheme to get Donald Trump, to take him out of being the next president of the United States, to deny you and me a vote. That's what they want to do. They are so afraid of Donald Trump. The only way to defeat him is to find a way to convict him of a felony and try to shoehorn the situation into some kind of result where he cannot run, where he's not eligible to run, or he has to be removed from office. This is wrong. This is unjust. These people that are committing these crimes should be ashamed of themselves. I hope that they're thoroughly investigated, they're brought up on the appropriate charges, and they are held accountable. Personally, I'd like to see them disbarred and charged themselves. The irony here is the RICO case that they brought against Donald Trump and others should be brought against them for committing RICO violations. That's just my humble opinion. As I always say, friends, you're going to have to study all this for yourself and make up your own mind. Folks, keep that mind free, never give up. And until next time, I am J.R. Dukes.